5863 is Representative Slater's second bill, the Fair Chance licensing bill. I was asked to just go over the substance and the mechanisms of the legislation and be available to answer questions anybody has about the actual content of the bill. As Representative Slater said, I think this legislation is a very logical corollary to the ban the box legislation that this General Assembly passed a number of years ago. And what it's designed to do is address what happens after you answer the question after a first interview when the opportunity arises to do that. What we have in Rhode Island, or as you'll hear from other witnesses, are lots and lots of laws that disqualify qualified individuals from getting occupational licenses based solely on an irrelevant and perhaps ancient criminal record. And what this bill is designed to do is promote some uniformity in the process, ensure that individuals are considered for occupational licenses based on their qualifications, based on the merits, and not simply based on a criminal record that may have no relevance whatsoever to getting the license. So what this bill does is it says a person cannot be denied an occupational license by the state solely based on a criminal conviction in the absence of some evidence that it is job-related. And I think we all can understand that there's an important value to doing that. Again, you'll hear from others who can talk from personal experience about that, but that's the essence of the bill. Consider individuals on their merits. So the way this would work is that the licensor, whatever agency that was of the state, would examine the criminal record and first make a preliminary determination: is there some job-related conviction that merits attention that might disqualify this person from the job? And the bill sets out some particular standards that the agency should look at to make that initial determination. And those are listed on page 2, lines 17 through 22. And to speed things along, I won't go through them. You can read them. After that initial determination, if the agency decides there may be something here that we think disqualifies them from the job because we do think it is job-related, there's then a second level where the agency considers very specific factors to make sure that it really is relevant, looking at the age of the individual when the crime was committed, exactly how relevant is it to the job, how long ago did the crime take place, what evidence of rehabilitation is there. After all those considerations are taken into account, the agency is free to decide, we don't think this person qualifies for the license because of their criminal record. What they have to do at that point is provide the individual the information, the rationale for that decision based on the criteria that are in the statute. At that point, the individual has the opportunity to respond and to appeal the decision to the courts under the Administrative Procedures Act. So the process is all designed to ensure that individualized determinations are made, that no criminal record in and of itself disqualifies a person from being able to qualify for a license. Again, it's just qualifying for the license. What employment follows from that is another matter, but at the very least, they should not be disqualified by the state itself from being able to get a license if they otherwise are qualified. The final thing that the bill does is have some reporting requirements, which are on the last page, page 4 of the bill, to be able to give a sense of how many people are in fact being disqualified based on their criminal records and why they are. And perhaps most importantly of all, the last section makes this officially and formally uniform so that when the legislature is considering bills in the future that deal with licensing, that deal with criminal records, this is the process that will be followed in these future licensing bills, so that, again, there's a uniformity to the process. You don't have different agencies making very different determinations based on very different statutes as to what qualifies as a conviction that warrants not getting a license versus another agency deciding differently. So we think it's a very common sense bill. This type of legislation is being passed across the country, and we hope that the committee will look favorably on it, and I'll be glad to answer questions at this point.